Y'all got it, y'all got it, y'all got it. So let's celebrate. Come on, Calvin, let's do this. Now I need everybody to clap your hands. Sing along with me. Let the people say, Jesus, Jesus, Jesus. Let the nation say, Holy Spirit. Yeah. Whole world says, and the beat goes.
Put your hands together. Come on, somebody.
Come on, let me put you down just a little. Hear you on the left, right, and the middle. Oh, yeah. We worship you. We worship you. Father, Jesus, Spirit, now that's the movement. You really feel it now. Come on, prove it. Oh, yeah. We worship you. We worship you. Come on, say it.
Greetings.
We worship you.
Greetings. 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 This is I, King Clifford Jefferson, a son of the Godfrey, the fifth caravan Jew, son of folk ruler of Jerusalem. I am the reincarnation of the King of Peace, as we know as King Edgar the Peaceful, or the Vicar of Christ, or Jesus Christ. It is July 25th, 2025, which is equivalent to the birth year 2975. I greet you in the name of all the ancestors, the predecessors, the successors, the descendants, the wannabe, should it be, and everything above that. Greetings to you all. I also greet you in the name of my queen, Sister Galveston from the House of Galveston, who gives me the ability to be able to stay fast and my prevailing for the interests of the English people, also known as the Anglo-Saxon Berbers. Greeting, Brother McGarrell from the House of McGarrell. Glad you're able to join me today for this beautiful lesson, which is the law of the office founded by a king. The law of the office founded by a king. This is a very, and very, very, and very important lesson in regards to me, your king, my office, the duties of my office, what's about to take place for all those who are of the peerage of English people that has been observed by those who are not English people, as the record reflects. So without further ado, let's get started with this marvelous lecture. Promise I won't hold you long. I'm going to give honor to Fred Hammond for that beautiful sermon. Ministry, music, we all love music. Hope we all do. I do. It puts a fire in me. Okay, so the title of this lecture is The Law of the Office Founded by a King. This is very important for you to understand because you must know who the one who is supposed to deliver you from the slavery, the bondage, the captiveness, the servitude, the indenturedness. Somebody's supposed to come back and deliver you, okay? Deliver you, very important. Deliver you from out of the hands of the possession of your enslaver. This is very important for you to understand this lesson. For all those who don't, we're sorry for you. Right? So without further ado, let's get started. The law of the office being found. Never get this teaching anywhere else, my brothers and sisters. All the smart comments talking about I'm a clown and we're a joke. The proof is in the pudding. You're never going to hear teachings like this anywhere else on the planet. Okay? Very important. You have abstract and you have concrete. Very important. You have adverse possession, you have lobby of season. These are the only two ways that you can have an inheritance. Whether it was handed to you, whether it was promised to you, those are the only way that you can have an inheritance. Usually the inheritance comes from the testator, the grantor, the owner, whatever synonymous term that you choose to use to uh, 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 relate to, that's best for you to be able to relate to. Choose your pick because there's many out there. Okay, so when you're talking about the beneficiary, the executor, and the testator. Okay, we know a lot of the so-called estates that we have. We're not even talking about real estate, the building on the land. We're talking about the estate itself. All right. Most of the estates that we have now, it results from our process of adverse possession. We need to write that word down. Adverse possession. Greetings, Countess Middleton. Adverse possession versus lottery of possession. Adverse means to take, lottery means to deliver. Very important. Very important. All right, because the majority of the time when you're hauled into court, it's an adverse possession, particular contractual agreement. And let me give you a good example. Okay, majority of the brothers and sisters owners of so-called property, you have a mortgage. Very important to understand this. You have a mortgage because it's a contract that you made with a third party. That's the mortgage company, the loaner. He's not a beneficiary, he's not the executor, nor is he the grantor. Okay? Very important. You have a solution to your problem right now. Okay? You have your solution right now. And it's on behalf of the law of the office of the king. We need to understand that. All the possessions that are now before the court, which usually wind up in what we call foreclosure court, results from adverse possession of the person claiming to have interest in the property that's at stake. Okay, you are the original owner of the property, but it now becomes subject to foreclosure as a result of some contractual agreement made by a third party who didn't have the authority to make such a contract agreement on behalf of the parties. Why do I say this? Because when you say adverse possession, this is called hostile, or what we call notorious possession. Hostile, notorious, open encroachment of property. We call that what you call that? You call that a squat. Okay, that's very important. The only reason you have the ability to be able to be or have to use the term adverse possession is because the states give them that right because they work for the states. Okay, they're incorporated within the state, so they're chartered in authority and everything within their charter that gives them authority was a result of the entity coming to existence by way of the state laws. And in this position or in this particular field of understanding, they are using adverse possession to hold property by way of the states that's any state within the United States do what they call, anybody know the term? Eminent domain. Eminent domain power. And eminent domain power only results in what we call exceeding power. Okay? No one has this power of adverse possession, eminent domain power, nor exceedment power, but the state. Because if it wasn't for the eminent domain, they wouldn't have the power to have adverse possession. Okay? Because they can only take property on the eminent domain that's what? Abandoned property. Okay? Abandoned property. The property is not abandoned. Why? Because it was passed down through heirs. Okay? Your mother, your father, the children. Sometimes you do it with a will. Sometimes it's not done with a will. It's called involuntary or voluntary alienation of property. This is called, in English common law, subinfeudation. So anything dealing with eminent domain power that the state has, which allows those corporations, all right, to now have adverse possession to take your property because those are the one who create the contract for you to become a party to the contract, not the party that has what we call equitable interest, but you only have a legal interest. Why? Because if you had an equitable interest, this would fall under the laws of what we call escheatment. Okay, escheatment is a process that happens when there are no heirs. That's the only way the state or anybody else can take property when there are no heirs. Okay? So if your mother opened a mortgage or your father opened a mortgage or your grandfather or grandmother had a mortgage that they didn't complete and that they died and you find yourself in foreclosure, The reason why you're in that position is a result of the adverse possession that they use to take the property. All right, and that's only as a result of the eminent domain power of the state that they allowed them to do that. Okay, and that's resulting of what they call the power of escheatment. In English common law, we call that inquisition post mortem. We're gonna go over those terms again. There. Okay. When land is street, that means there are no heirs. Okay. Nationality is not even a question. The fact that you are an heir, we know what heirs are, descendants. Okay. Are descendants. So the fact that you are in fact an heir to the property in question, where we're talking about estate or the real estate, all right, you have a right or equitable interest in the property over or versus a legal interest of the property, which is the adverse possession interest that the other party has. Okay, and the only reason, once again, they have that authority is a result of the eminent domain power of the state. And the only reason why the state had that eminent domain power because they are claiming that there are no heirs. If there are no heirs, then there could be no eminent domain power for the state to allow an adverse possession to be done on anybody else in regards to the interest of property that they claim to have an interest in. Okay, very important. You're not being brought into court by who? The state, are you? No, you're being brought in court for a third party who doesn't have an interest in the property or the real estate. Why? Because they're not in there. Very important. Let's look at the law of office found. Let's get on to the study. The law of the office found. The ruling of the case below should upset everyone but the informer. And I have been saying and continue to say this in the conditions of this country. This is from Bible believers, okay? This is a religious organization talking about the law of the office being found, okay? Or the law being inquisition or inquest, or what we call traverse, okay? All synonymous terms, right? So it says the ruling of the case below should upset everyone, and it should, but the informer. And I have been saying and continue to say this in the condition in this country. Also contained in the Blackstone's quote, I got the whole volume down there, is mentioned rights of the British in their Declaration of Liberties, but not so. Read the Declaration of Rights of 1689, the third section. It is made clear that the rights of the corporation and the grantors take precedence. You know, when we're talking about corporations, we're talking about royal corporations or proprietary corporations, or royal colonies or proprietary colonies in this point in time, right? So it says, British in their Declaration of Liberties, but not so. Read the Declaration of Rights of 1689, the third section. It made it clear the rights of the corporation and the grantor takes precedence. Office found depends on the context. If you're talking about the king, it refers to an heir or successor and removing holdings from aliens. This is called alienation or what we call subinfeudation, because subinfeudation results from alienation property from the original or the proper owner. Okay, if talking about a sub corporation, the corporations are protecting their grants to keep the grants out of the hands of an alien, friend, or an enemy. Okay, in either case, once office is found, the land or possession reverts back to the corporation, the state, or the king, or the sovereign. Once again, in either case, once the office is found, the land or possession reverts back to the corporation, the state, which is a corporation, or the king, which is a corporation. One claims to be sovereign, and the other is not. Okay. I wonder if this is why we all were declared to be enemy aliens in the 1933 enactment. The landmark case Fairfax Devizes versus Hunter Leslie absolutely defines a treaty and it's the supreme law of the land, and how the Treaty of 1783, they're talking about the Treaty of Paris, and the Treaty of 1814 protected the king's holdings, period. In the case below, you will see what the king has been doing in recapturing corporate holdings that came about after the two treaties were passed because the holdings were in the hands of aliens. Okay? In the hands of aliens. They gave you a case, Fairfax Devizes and Hunter Leslie, which we're going to go to. Once again, alienation is what we call subinfeudation. Once again, alienation is called subinfeudation. That was created by Edward I under the legislative enactment of the English Parliament called Queen Imperatoris in 1290. Okay? Queen Imperatoris in 1290. This is New Jersey reception statutes that are enacted in this present day. Let's read a little bit from Wikipedia what this says. Some directional orders have been laid down in regards to Queen Imperatoris in the Magna Carta, the provisions of Oxford, and the scanty legislation of Simon de Montfort, 6th Earl of Leicester. Edward I set about to rationalize and modernize the law during his 35-year reign. The first period from 1272 to 1290 consists of the enactment of Statute of Westminster in 1275, the Statute of Gloucester in 1278, and the incorporation of recently conquered Wales into the realm. These were followed by the statutes for warrant or means to order to show just cause or by what authority, and the statute of mortmain, which means mortmain means dead pledge. Okay, the latter was designed to stop the increasing amount of lands which were ending up in church ownership. When we're talking about church, we're talking about the Roman Catholic Church, not the English Church, which we are, the English Church of England, but the Roman Catholic Church. The Statute of Westminster 1285 contained the famous clause, the law governing entail estates, not fee simple, but entail estate, which was under the legal maxim, de donuts conditionalibus, which shaped the system of entail in estates. The Statute of Winchester was passed in 1285. This was followed by Queen Imperatoris 1290, which was only about 500 words in length. Okay, all those who are of my peerage need to understand this term. Right here. Legal legacy of Queen Imperatoris in United States law. Okay, we're talking about a law, a legislative enactment by Edward I being encoded in United States or the state's law. Okay, very important. Although it is a matter of debate whether Queen Imperatoris was the effective law within the colonies, the effect of the statute is still present in the United States land laws. Without a doubt, the United States Constitution and various state constitutions and legislative acts have made Queen Imperatoris moribund, in fact, meaning about to die, or damn near on his deathbed. But the language of the land law still sounds medieval. It takes its concept from the time of Edward I and before. The following list of words common in the United States land law are from the Norman England with their modern meaning in the United States. Do we understand that? Let's go backtrack a little bit. Let's backtrack a little bit. Key point. Now, these are all these cases in New York. New York was actually part of New Jersey at one particular time, going back to the Doherty under Lord Cornbury. He was the world governor of New York. Colonial America and United States concerning grants of the English colony. It didn't say British colonies. It didn't say Scottish colonies. It didn't say Irish colony. It didn't say Danish. It didn't say French. It didn't say Portuguese. It didn't say Spanish. It said grants of the English colonies. We must understand that. The English colonies of North America were founded upon royal grants or licenses. Specifically, British colonization of North America was by charter colony or proprietary colony. In this sense, they were founded upon the principles outlined by Queen Imperatoress. Everyone heard that, right? In this sense, they were founded upon the principles outlined by Queen Imperatoress. The territories were granted under conditions, all right, by which English law controlled private estates of land. We ain't even talking about real estate. We're talking about estates of land. And when we say estates of land, we're talking about land, subsurface, water rights, and air rights. The colonies were royal grants. An entire province or any part of it could be leased, sold, or otherwise disposed of like a private estate. In 1664, the Duke of York sold New Jersey to George Carteret and John Berkeley. Okay, the sale was effected by what? A deed of a lease and release. This is a land can be conveyed by a deed, but if it's not based upon operation of law, then it's a violation of law because there's only two ways: adverse possession and lottery of season. Lottery of season is by way of delivering the conveyance from the grantor to the beneficiary or to the grantor to the executor on behalf of the beneficiary. When you're talking about adverse possession, then the only thing you're talking about is just going up, making a claim to it when nobody else is making a claim to it, and then arguing in the court of law to validate it. All right, very important. But as we can see here, all the real estate, estates, and land concerning land here in North America at the time of the British colonization. Okay, that meant that the British colonization was not the same as the English colonization. The English colonization was the colonization that the English law allowed the British to colonize on the English soil. Okay, very important that you understand it from that perspective so you won't get lost. Let's get it. All right. Go to the case now. Fairfax, Devizes, and Hunter Leslie. 1812 case, United States Supreme Court. Error of the court in the appeals of Virginia concerning a proprietary colony called Northern Neck of Virginia. All right, the Northern Neck of Virginia. This is the coastline of Virginia. All right, very important. Look at the language from the Supreme Court in regards to possession or adverse possession by an enemy or friendly enemy. You have no rights to claim on any land. Okay, I'm not saying it. This is what the case law said. A alien enemy. All right, when we talking about alien enemy, we talking about an alien, a naturalized citizen, a foreigner that's not a friend but an enemy. Okay, meaning that this is a time of war. Okay, this is a time of war. All right, so we got friendly aliens and enemy aliens. Okay, very important. An alien enemy may take land in Virginia by devise and hold the same until an office is found. There we go, that term, office found. Okay, title should have been perfected by possession in the British Treaty of 1794, confirming the title to those lands and the devising of Lord Fairfax. We're going to find out who this gentleman is in a minute. We're talking about Lord Fairfax, okay? All right, whether we're at a time of peace or a time of war, we're talking about aliens, okay, making claims by way of purchase, okay, not by descent though. Okay? Because if it was about descent, then it would be entail. Very important. An alien can take land by purchase, though, though, though a not, watch out. An alien can take land by purchase, though a not by descent. At the common law, or in any other word, he cannot take it by the act of law, but he may by the act of a party. You hear that? When we say by act of law, we're talking about by operation of law. We can take it by operation of law because we're not aliens. They are aliens, so they can't take it by operation of law. They have to do it by act of a party, by meaning getting the tricking you. Okay? Tricking you. There is no distinction whether the purchaser be by grant or by devisee. In either case, the state vests in the alien not for his own benefit, but for the benefit of the state. Did you hear that? Did you hear that? So you only got a right in easement. You don't have the right to totally and fully possess it. You got the right to use it until office is found. Okay? All right? Either by the king, either by his officer, or either by an heir. And you are heirs. Okay? Because if you wasn't an heir, then that meant that the government will claim escheatment. But the government or the state of the United States or the government of the state, it don't have you in court talking about your property. It's a third party in court talking about they have an interest in your property. Okay? They don't have an interest in the property because their interest is average possession, and you can't have average possession until you have eminent domain power through power of escheatment. And they can't even use none of the three because you are an heir. The state can have escheatment if an heir still exists. Okay? If an heir still exists, the state does not have the power of escheatment. Therefore, it has no eminent domain power. So it's just abandoned property waiting to be claimed by an heir. Okay? If you don't go and claim it, then hey, it's bonded vacatinio. If that makes sense to anybody who's watching this lecture, please give me a thumbs up in the chat line. Okay? Let's move forward. There is no distinction whether the purchase be by grant or by devising. In either case, the state only vests in the alien not for its own benefit, but for the benefit of the state. Or in the language of the ancient law, he has the capacity to take, but not to hold land, and they may be seized into the hands of who? The sovereign. Okay? By what? The founding of office. Okay? The founding of office. Let's read a little bit more. Until the lands are so seized, the alien has complete dominion over them. Did you hear that? The alien has complete dominion over them. We're not talking about a friendly enemy. We're not talking about an enemy. All we know is that they're alien and they got complete dominion over the land. Okay? Until the land is seized by either an heir, all right, or the king. All right. If either the king ain't there or the heir, then it falls under the crown called inquisition postmortem, meaning the law of escheatment, meaning there are no heirs. Until the land are so seized, the alien has complete dominion over them. This is why they hold your land. He is a good tenant of the freehold and a preside on a common. On a preside of a common recovery. You hear that? On a preside on a common recovery and may convey the same to the purchaser. It seems indeed to have been held that an alien cannot maintain a real action for the recovery of land, but it does not then follow that he may not defend in a real action his title to land against all persons but the sovereign. Did you hear that, brothers and sisters? But the sovereign. To preside on a common recovery action. Common recovery means you change it in entail estate into fee simple. Once again, you're changing an heir estate, which is entail, to an estate that's fee simple, means you can convey it to anybody, okay, by way of a deed, not by law, because lobby of law confirms that the lobby of deed is valid. Okay, very important. In respect, these general rights and disabilities as to real property, there is no difference between an alien friend and an alien enemy. Did you hear that? In respect to this argument, there is no rights and disability as to the property in question in regards to an alien, whether you're a friend or you're an enemy. Why? Because we don't care if you're a friend or an enemy when you're We don't care if you're a friend or enemy in regards to property, because the property don't belong to friends and enemies who are aliens. Okay, very important. Very important. During the war, the property of alien enemies is subject to the confiscation under the law of war and peace, and their civil capacity to sue is suspended. Okay, it's suspended. Now, who are we talking about? We're talking about Fairfax Devising. Okay, let's find out who this guy is before we go further. Thomas Fairfax, 6th Lord Fairfax of Cameron. Thomas Fairfax, 6th Lord Fairfax of Cameron, was a British-born planter. The only member, listen, y'all, he was there from 1693 to 1781. The only member of the British period, it is a English period, it says the British period, to permanently reside in British America. Fairfax owned the Northern Neck Proprietary and the colony of Virginia, where he spent the majority of his life. The proprietary had been granted to Fairfax's ancestor, John Culpeper, first Baron Culpeper, by Charles II of England in 1649. Let's take a look at him. Let's look at another Thomas Fairfax first before we go there. Another Thomas Fairfax. A British peerage, not English peerage, but a British peerage. So that, in fact, means they are aliens, okay? Claim to be friendly, but yet they are enemies, okay? So Thomas Fairfax was an English, no, we know he wasn't English, brothers and sisters. He was an English Army officer, or British, to say, a British Army officer and a politician who commanded the New Model Army from 1645 to 1650 during the English Civil War. You hear that? The English Civil War. So these are two Thomas Fairfax who are descendants going back to John Culpeper. Okay? Who is John Culpeper? Let's check him out real quick. John Culpeper was born about 736. No, that's not what. John Culpeper. Right here. Right? So Fairfax claimed to be descendants of John Culpeper going back to the 14th century. Okay? Going back to the 14th century. This is very important. Oh, I could have just found it here. Let me go back there. Thomas Fairfax. Thomas Fairfax, 6th Lord Fairfax of Cameron. So right here. On his Virginia estate, Fairfax developed a profitable operation based on forced labor of several hundred black slaves. A steadfast loyalist during the American Revolution, he was largely protected from the loss of his property due to Fairfax's friendship with who? First President George Washington. Several places in northern Virginia, in the eastern panhandle and western Virginia, are named for him, including Fairfax County, Virginia, and the city of Fairfax. Okay? Very important. He said his ancestor was John Culpeper, first Baron Culpeper. Let's click that real quick. See where this takes us. Okay. The Culpeper family resided in Kent and Sussex during the late Middle Ages, and certain of them served in the administrative capacity, particularly as High Sheriffs of Kent and in the stewardship of Romney Marsh from the early as of the reign of Edward III, 1322 to 1377. So if they're claiming to be have some type of interest in an estate, okay, that lasted through the 18th century, then they must have been kindred to King Edward III. And King Edward III was not of British parentage. He was of English parentage. So someone's been lying to us, okay? Someone's been lying to us because this so-called Fairfax was a slaveholder, okay? And he owned black slaves, okay? This is very important because we know through the 14th Amendment, we as so-called slaves were emancipated, okay? And then our citizenship was construed to the common law of England in light of the common law history as stated in what? United States versus Juan Kimmel Ark, okay? It was stated in United States versus Juan Kimmel Ark about the status of people identified as black slaves, now called free slaves or free men and women, okay? Whose identity must be construed to the common law of England and the history of that common law, which goes back to Henry II of the Plantagenet crown. Forebearer of Edward I, okay? Very important. We must understand that. Fairfax and Culpepers were not the true heirs of Edward I or Edward II or Edward III, which was the reason why we had the conflicts in this present day, which resulted from what we call the 100-Year War or the War of the Roses, okay, which we're going to talk about in a second, okay? So as we can see, Thomas Fairfax, all right, a slaveholder, all right, at the time of the American Revolution, who assisted George Washington to help assist and overthrow the land that actually belonged to who? Those people identified as black slaves. Because I'm letting you know that you are, in fact, the English Anglo-Saxon Berbers. This is your land. You are the heirs. They stole it from you. How we know it? I got a case law to back this up, okay? Let's go to Chisholm versus Georgia. No, United States versus Juan Kimmel Ark. Let's go there first. United States versus Juan Kimmel Ark, 1898 case, Supreme Court, New Jersey. It says, matter of fact, let me go here first, right? So I can paint the picture. This is United States versus Lee, 1882 case, all right? Let's start with the Stuarts first and see that it was the Stuarts or the British peerage who stole the estates of the English peerages as a result of us what? Falling asleep. All right? So as a result of the heirs falling asleep, the land automatically escheats to the crown. If the crown is not there, then it escheats to what they call the states under the eminent domain power of the states. And this is where you get the eminent domain power called compulsory purchase or what they call prescription of sovereignty, all right, which allows for notorious, adverse, and hostile takeover. That's the language of conquerors. That is the language of invaders. Why aren't y'all listening to me? Okay? It says in United States versus Lee, in all cases where a title to property, we're still talking about the topic of this lesson, the law of the office found by who? A king. Okay? In all cases where the title to property came into controversy between the crown and a subject, whether held in the right of the person who was the king or as a representative of the nation, the petition of right presented a judicial remedy. A remedy which this court, on full examination, Supreme Court, in a case which required it, held it to be practical and efficient. There has been, therefore, no necessity or justification for suing the officers or servants or subjects or heirs of the king who held possession of such property when the issue could be made with the king himself as what? A defendant. As a defendant, okay? This is very, very, very important. We're going to see this also in another case. Let's read a little bit more. Another reason of much greater weight is found in the vast differences in the essential character of the two governments as regards to the sources of the depositories of the power. Notwithstanding, listen, y'all, notwithstanding the progress which has been made since the days that the House of Stuarts and stripping the crown of its powers and prerogatives. You should hear that. The House of Stuart, which goes back to King James, which got to start from Elizabeth I, which was all slaveholders of black people. Okay, the English people now identify as black as a result of the Atlantic slave trade, going back to the Portuguese and the Spanish crown. Okay, under those crowns, okay, through what we call the war, the Spanish conquest, which brought forth the Spanish succession. All right, which was preceded by the Castilian succession, which were all done by Roman Catholics who enslaved the English people. How I know it? Let's prove it. Notwithstanding the progress which has been made since the days the Stuarts and stripping the crown of its powers and its prerogatives, it remains true today that the monarch is looked upon with too much reverence to be subject to the demands of the law as ordinary persons are. And the king's loving nation will be shocked at the spectacle of their queens being turned out of her pleasure garden by a writ of injectment against a gardener. The crown remains the fountain of honor and the surrounding which gives dignity and majesty to its possessor, are cherished and enforced all the more strictly because of the loss of the real power in the government. It is not to be expected. It is not to be expected, therefore, that the court will permit their process to disturb the possession of the crown by acting on its officers or agents. Did everyone hear the language of the United States versus Lee in regards to the crown, the English crown versus the British crown or the Scottish crown? Two different crowns, okay? Two different crowns. That only came by way of the Treaty of Union. We just said that all the British colonies were subject to Quin Imperatoris, the law preventing the alienation of land. If the land is alienated, then who was it alienated to? A damn alien, okay? Whether it was a time of war or a time of peace, the alien does not have the right to possession of estates that belongs to heir. Through the power of, not through the power of adverse possession, not through the power of eminent domain, and damn sure not the power of achievement. Okay? We must understand the language. Now we didn't qualify that what resulted from the 100-Year War, all right, and the War of the Roses, which gave birth to the House of Tudors, okay, a cadet branch of the Lancaster branch of the branches of the Angevin house, which was started by King John, the one who signed the Magna Carta. Okay, very important. Now we have United States versus Juan Kemar. Okay, it's going to tell you in this case that they help assist in the overthrowing of the English crown by assisting the British crown, as we've seen by Thomas Fairfax, with assisting Thomas Jefferson to become president. Okay, that's why the Treaty of Paris of 1783 went smooth. Okay, ratified January 14th, 1784, my birthday. All right, it said the framers of the Constitution were familiar with the distinction between Roman law and feudal law, so they damn sure know who William the Conqueror was, between obligation based on territorialities and those based on the personal and visible character of origin. And there is nothing to show that in the matter of nationality, they intended to inherit the principles deriving from the regal government, that's the crown government, which they had just assisting in overthrowing. So, as we see in the United States versus slave, progress had been made from what the Stuarts had done and overthrowing the crown. Now it's being overthrown again by who? The framers of the Constitution. You see it right here, brothers and sisters. Am I lying? It just said it. Let's get a little bit more insight. Let's get a little bit more insight on the topic at hand. Manifestly, when the sovereignty of the crown was thrown off and the independent government established, every rule of the common law and every statute of England obtaining in the colonies in derogation of the principles on which the new government was founded was abrogated. Did you hear that? It was abrogated. The states, for all national purposes now, embraced in their constitution, became one, united under the same de facto sovereign authority and governed by the same laws, but they retained their jurisdiction over all persons. That's you, my brothers and sisters. The Negro, the Black, the colored, and whatever term they got to you. I'm telling you that that's not you. You are the English, Anglo-Saxon Berbers. You are of the just commune because you have a folk right. That folk right is the uncoded Magna Carta versus the written Magna Carta that John was forced to write as a result of rogue barons. Which was one of those barons? Thomas Fairfax. Okay? The state for all national purposes embraced in the Constitution became a one unified under the same sovereign authority and governed by the same laws, but they retained the jurisdiction over all persons and things within their territorial limits, except which were surrendered to the general government or restrained by that Constitution, and protection to life, liberty, and property rested what now primarily with them. So far as the just commune or folk right that belong to us, the indigenous, aborigines, the or whatever else you want to use related to the rights of persons was concerned, the colonies regarded it as their birthright and adopted such parts of it as they found applicable to their condition. Need I say more, brothers and sisters? Need I say more? What is our problem? Okay? Now, as it said, it says that Thomas Fairfax, go back there. Thomas Fairfax was the only member of the British peerage to permanently reside in British America. Okay? In British America. So what is the peerage of Great Britain? When did the peerage of Great Britain start? Very important. Because it's different from the English peerage. All right? There's a difference. Right? If you are my nobility, then it's up to me to bestow that nobility back upon you since you claim it don't exist. All right. If you ain't in there, then that meant that all the land is ceded back to the crown, and I'm the only person representing the crown. So I'm the only one that can determine the peerage of England. I didn't say the peerage of Great Britain or the peerages of Scotland or Ireland. I said the peerage of England, totally different from the peerage of Great Britain. Why? Because the peerage of Great Britain comprises of all extant peerages created in the Kingdom of Great Britain between the Acts of Union of 1707 and the Acts of Union of 1800. Okay? Once again, the peerages of Great Britain comprises in all extant peerages created in the Kingdom of Great Britain between the Act of the Union of 1707. Prior to that, there was no peerages of Great Britain. The only peerage that you had was the peerages of England. Let's look at that real quick. So Thomas Fairfax did not have a right to any estate and land here in what they call British North America. Nor did the British have the right to any land that they call British America, because this was not called British America. This was, in fact, England. Okay? This was, in fact, England. Undisputable fact. The peerage of England comprises of all peerages created in the Kingdom of England before what? The Acts of Union of 1707. Did you hear it? The peerage of England comprised of all periods created in the Kingdom of England before what? The Acts of Union of 1707. Now that's mighty strange because where I'm about to go right now. Right? Where I'm about to go right now. So the peerage of England was distinguished from the peerages of Britain because prior to 1707, there was no peerages of Britain. Okay? I mean, the term Britain, Great Britain, or whatever, that term did not exist. Okay? So we can exclude what they call Great Britain over there. All right? We can exclude that from the argument. All right? Because we're not talking about any peerages of Great Britain that came to unification with England and its own peerages. All right? Very important. And we've seen that the England was here before 1707. So it says in New Jersey Provincial Council, which is called His Majesty's Council, which means the peerages of His Majesty, was the upper house of New Jersey legislature and colonial rule until it was replaced by New Jersey Legislative Council under the New Jersey Constitution of 1776. So from 1702, my brothers and sisters, to 1776, guess what was ruling? The Crown of England, right here in New Jersey, by a British monarch, Queen Anne, okay? She didn't have the right to sit there, but she was, all right? But she left everything intact. She left everything intact, all right? How we know that? Let's go here. Queen Anne's War. What's this all about? Because the war lasted at about the same time her butt was in office. So at the same time Queen Anne was in office from 1702 to 1714, she had a Queen Anne's War going on, which is called the Third Indian War. Now, why is she warring with Indians when she got a war going on between Great Britain, France, and Spain? All right, why? Since Queen Anne War from 1702 to 1713, or the Third Indian War, was one of a series of French and Indian wars fought in North America involving the colonial empire of Great Britain, France, and Spain. So before Great Britain existed, before France even existed, before Spain even existed, damn it, this was England. Okay? It was England because we just said the crown of England was right here and called His Majesty's Crown Council in 1702. At this time, Queen Anne's fighting the Third Indian War in 1702, and she's not an English queen. She's a queen of Great Britain, okay? And this war was a result of what? The Spanish succession, okay? Not over there in Spain. Not over there in Spain, over here. Britain ain't even in question right now. Why? Because we know Britain didn't come about to 1707. 1707 was the unification under the Acts of Union of 1706. Prior to that, the only government that's functioning under the itinerant court was the Kingdom of England that's right here in New Jersey. If everyone understands that, please give me a thumbs up in the chat line. Okay? So at the same time, the English crown under the English peerage, all right, is right here remaining intact. Queen Anne is fighting the war with the so-called natives here in North America called the French and Indian War, involving Great Britain, which is way across the damn water, France, which is way across the damn water, and Spain, both on the same continent, okay? It took place during the reign of Queen Anne of Great Britain. In the United States, it is often studied as a standalone conflict under this name, although it is also viewed as an American theater of the War of Spanish Succession. Did you hear that? It said the Spanish Succession. It didn't say the Spanish Conquest. The Spanish Conquest was in 1492 under the kingdom of what we call the kingdom of, what was it? The kingdom of Spain. Okay? The kingdom of Spain. Let's look at it real quick. Let's take a good examine. The War of Spanish Succession. Okay? You can't have a war of Spanish succession unless you're in the possession of something to have it succeeded to somebody else. And we know when the Spanish took it, it was called the Spanish conquest of what they call North America, because the territory we're talking about is here, what? North America. That's 1491 to 1492, which involved what we call the Spanish Empire. Let's look at it. All right. The Spanish Empire, sometimes referred to the Hispanic monarchy, or the Catholic monarchy, was a colonial empire that existed between 1492 and 1976. In conjunction with the Portuguese Empire, it ushered in the European Age of Discovery in 1492. So you couldn't have a Spanish succession until you had the Spanish Empire. By who? Queen Isabella and Ferdinand II. Everyone needs to understand this science, because it's a science, okay? This knowledge is a science. Okay. 1492 to 1976 was the Spanish Empire, in which Queen Elizabeth, through the Queen's Anne War, was fighting over what they call the Spanish succession. So let's go back to the Spanish succession. I teach. The War of the Spanish Succession was a European great power conflict fought between 1701 to 1714, the death of Charles II of Spain. Now we know Fairfax, Thomas Fairfax, got his grant from Charles. Okay, not Charles of Spain, but Charles of England. The death of Charles II of Spain on November 1700 without children resulted in a struggle for the Spanish Empire. Okay, so we're talking about from 1492 to the 1701. We're talking about the Spanish Empire. Okay, between rival claimants, Charles named his heir as Philip of Anjou, who was backed by his grandfather Louis XIV, a friend. His opponent, Archduke of Charles of Austria, was supported by the Grand Alliance. Significant related conflicts was also associated with that. The Great Northern War and Queen Anne's War, which we just talked about. All right. Very, very important, right? Because we know that the Spanish succession, all right, was a result of the Spanish Empire and the Portuguese Empire. And we know they were involved in the Spanish conquest, okay, which was resulted in what we call slavery. All right. Very, very important. All right. So the War of the Spanish Succession, 1701 to 1714. Okay. Now we're going to look at the Spanish, go back to the Spanish Empire. So we know the War of Spanish Succession that Queen Anne was fighting for. She wanted the spoils of the war. Okay. And the founding fathers wanted what was left after that. Okay. And remember, we're talking about right here because we're talking about French and Spanish conflicts here on this landmass, which was called British Empire at that particular time. It was called the French Empire under the Spanish Empire under what we call the Crown of Castile. All right? Not the Kingdom of Castile, but the Crown of Castile. Totally different, my brothers and sisters. So the Spanish Empire and the Portuguese Empire are related. Okay? Once again, the Spanish Empire and the Portuguese Empire are related because it results in what we call invasion, conquest, through what we call the eminent domain power or purchase power, compulsory purchase power, which now the state has taken the undertaking. All right, very important. Portuguese War Empire. Let me go ahead. Okay, I know where I want to go. The Castilian War of Succession. That's where I want to go. Where's that at? War of the Spanish Castilian Succession. All right, because what the Spanish War of Succession and the Spanish conquest, I mean, pardon myself, the Spanish conquest resulted from um uh the War of Spanish Succession that took place under Queen Anne's War resulted from the Spanish conquest. Okay, and the Spanish conquest of North America was a result of those conflicts that resulted from the Spanish Castilian War of Succession. Okay, the Castilian War of Succession. Let's go there and take a look at that. Right, War of Castilian Succession. The War of Castilian Succession was a military conflict contested from 1475 to 1479 for the succession of the Crown of Castile. That's going back to who? Queen Isabella and Ferdinand II. Once again, succession for the Crown of Castile. That will be the Kingdom of Spain, the Spanish Empire. Let's look at that real quick. Spanish Empire. Let's look at it. Connect these dots. Here. The membership of the Spanish Empire. Trans-Zamora, Habsburg, Capitan Dynasty, Bourbon, House of Valios, Burgundy, House of Capet, House of Bonaparte, and House of Savoy. This is the Spanish Empire founded by who? Right, okay. With the marriage of heirs apparent to their respective thrones, Ferdinand of Aragon and Isabella of Castile created a personal union that most scholars view as the foundation of the Spanish monarchy. Okay, you hear that? The marriage of Isabella of Castile and Ferdinand of Aragon, known as the Crown of Castile, became known as the Spanish monarchy or the Roman Catholic Spanish monarchy. We must understand that. Okay, so that meant that there was a Spanish succession, which was conflict that resulted in Queen Anne's War because Queen Anne wanted what was left over from the Spanish succession, and the Spanish succession was succeeded from the Spanish conquest. Okay, going back to wars that they had on the Iberian Peninsula with the true inhabitants of the Iberian Peninsula. Okay, that goes back to the true Castilians. Okay, of the Kingdom of Castile versus the Crown of Castile, because the Crown of Castile was under the authority of Ferdinand of Aragon and Isabel of Castile. Okay, very important to make that distinction. Okay, so the War of Castilian Succession brought on the War of the Spanish Succession. All right, because the War of the Spanish Succession resulted from the Spanish conquest here in North America. Now, the Castilian War of Succession goes back to the conflict that resulted of how we lost our state, i.e., the Plantagenet crown, which resulted in what we call the Castilian Civil War. With who those Castilian with who the Crown of Castile, okay, the House of Trans-Zamora. Let's just look at it. The House of Trans-Zamora, the Castilian Civil War. Got to 8 o'clock, so I gotta hurry this up. The first Castilian War, okay? We ain't talking about the War of Succession. This is the process. The first Castilian Civil War was a war of succession over the Crown of Castile, okay? That lasted from 1351 to 1369, okay? So two families fighting, brothers and sisters. The Roman Catholic Spanish kings and queens, and the English and Spanish families, okay, which were all tied in by what we call marriage. We're about to see it right here. And it goes back to the 100-Year War. The first Castilian War, before you got to the Spanish what we call the first Castilian War, before you got to the Spanish Castilian Succession War, then the Spanish Conquest, and then the Spanish Succession War, then Queen Anne's War. We got to take it back to the original Ruler Tudor. Original Ruler Tudor was the first Castilian Civil War, which was the War of Succession over the Crown of Castile that lasted from 1351 to 1369. The conflict started after the death of King Alfonso the 11th of Castile in March 1350. Let's look at the belligerents in this conflict. And we are Transmore. Let's just look at it. The belligerents. Commanders and leaders. Henry of Trans-Mamara, all right, and Peter of Castile, Edward the Black, John Gaunt, and James IV of Majorca. Peter of Castile is the son of, if I'm not mistaken, a Castilian king, but Edward the Black and John Gaunt are the sons of Edward III, the King of England, okay? The King of England, John Gaunt and Edward the Black Prince were sons of Edward III, son of Edward II, son of Edward I, son of John, son of Henry II, son of Godfrey the Fifth Jew, son of Fulk, ruler of Jerusalem. Okay? So the conflict that's dealing with Queen Anne's War resulted from the War of Spanish Succession that resulted from the Spanish conquest going back to Isabella of Castile and Ferdinand II, which resulted from the Castilian War of Succession, which resulted from the war or succession with the Crown of Castile as a result of the conflict they had against each other. Very important to understand that timeline. And all that was preceded by the 100-Year War, right there. The 100-Year War. Let's go ahead. So in closing, so that was going to keep it long. The Peerage of England. That's probably no understanding. I showed you this the other day. I'm going to close out on this. British kings and queens who points out. British kings and queens who supported and profited from slavery. We're talking about for profit and non-profit. I talked about in prior lessons. I'm not going to go do that today for the sake of time, but I just want to close out on this because it's relevant, right? King Charles III and Prince William have expressed profound sorrow at the atrocities of slavery, but neither had publicly accepted the Crown's central role in the trade. What Crown's role? The British Crown. Over a period of 270 years, 12 British monarchs sponsored, supported, and profited from Britain's involvement in slavery, according to the historian. Which one they had first? Elizabeth I. Okay? Elizabeth I, the daughter of Henry VIII, the son of Henry VII, the founder of the House of Tudors cadet branch for the Lancaster branch. All these had the hand and slavery of the African, Negro, black, colored people, which are actually the English people, which I have proved through this lecture. Okay? So Elizabeth I, James, Charles, who else we got here? Charles II. I'm gonna go right up to Queen Anne. James II, William and Mary Orange, I close out on this one. Queen Anne, right? Queen Anne is remarked, remember, for the union of the England and Scotland in 1707, which formed the United Kingdom of Great Britain. She also dramatically expanded the nation's slave trading activities by securing from Spain in 1713 the Asencio de Negro, meaning a contract for the Negroes. a monopoly right to supply and enslave African people to Spain colonies in South America. This contract was fulfilled by the South Sea Bubble Company. Okay, so here is your proof, brothers and sisters. Queen Anne, our British queen, was overseeing the English crown that protects the English peerages, which is based upon our titles and ability granted by our king. And since we were no heirs, since we claimed to be not existing anymore, the land automatically ceded back to the crown, which I represented. So for you to have your title and ability restored to you, that's fall under this term. I'll close out on this term. Fount of honor. As a result of the founding of the king's office. Fount of honor. The fount of honor is a person who, by virtue of their official position, has the exclusive right of conferring legitimate titles and ability and orders of chivalry on other persons. During the High Middle Ages, European knights were essentially armored mounted warriors in feudalism. By virtue of its defining characteristics of subjugation, it was a common practice for knight commanders to confer knighthood upon their finest soldiers, who in turn had the right to confer knighthood on others upon attaining command. So this is called Queen of Pretorius. Let's look at it before I close out. Queen of Pretorius. Prime example of Queen of Pretorius. Queen of Pretorius, a statute passed by Parliament of England in 1290 during the reign of Edward I that prevented tenants from alienating, transferring their land to others by substitution, instead requiring all tenants who wish to alienate their land to do so by what they call substitution. Okay? Substitution. So there you have it, brothers and sisters. With all the content I got in regards to real estate and property law, this lesson will fill in the gap for those who don't have a clue about what it is I'm talking about. All right, so with that, thank you all for joining me today for this lecture on regards to the laws of the office founded by a king. That I'm agreed to, as I always meet you, that's in peace and love.